What I want to do in this lesson is talk about bilateral investment treaties. Now, this is going to form part of a series of lessons, 3 or 4 lessons, that are going to be essentially explaining the structure of international investment law. And this is done mainly through the context of the treaty law on foreign investments. So we're going to talk in this lesson about bilateral investment treaties. In the next lesson, we're going to talk about one particularly influential influence on the investment law regime, which is that of the European Union as a sort of as a regional investment bloc, especially considering the fact that the European Union is the largest exporter of foreign direct investment. And then in the lesson after that, we'll talk about the role and the space for multilateralism within the investment law regime. So this is taking an introduction to the treaty law pertaining to the protection of foreign investments. And the essential way in which we structure investment law, and we see investment law being structured, is that of a bilateral nature. It is a bilateral system. And we mentioned this previously, and when I say a bilateral system, I'm obviously going to qualify that by saying it is a mostly bilateral system. There are instances of regional integration, which we'll get to. There are instances of multilateral integration, which we'll get to. However, for the most part, it is bilateral in nature. And so this has been the case for a while, essentially. And there have been attempts to multilateralize the regime, to create a more multilateral agreement on investment. Following the end of the Second World War, for example, there was the introduction of the Havana Charter for the International Trade Organization, one of the provisions of which, Article 12, specifically Article 11 and 12 to an extent, had rules, substantive rules on the regulation of foreign investment. The aim here was to create a WTO-style agreement following the end of the Second World War, but of course this never materialized. It didn't materialize for a number of reasons. One of the reasons for this was, and at least the most substantial reason for this, was the disdain by the United States for the establishment of the ITO. It came to a point when the Truman administration had realized that they were never going to be able to get the ITO agreement, the Havana Charter, passed into law through Congress, owing to the fact that there was a shift in the political structure of the United States, with the Republicans retaking the houses of Congress, and B, because of the growing divide between East and West and this growing Cold War that was beginning to take shape. And then couple that with the fact that the 1947 General Agreements on Tariffs and Trade, which was originally supposed to be an interim agreement that essentially was supposed to be established to manage the interim while this ITO was being agreed, was serving its purposes. It was doing quite a good job in regulating trade. So it seemed that the the ITO was not a particularly fruitful avenue for policy and for political, essentially for using any kind of political revenue to try and actually get an agreement across. So it eventually died. Since the late 18th century, investment has been regulated mostly on a bilateral level. And this is done first through what were known as friendship, commerce, and navigation treaties, and then subsequently through bilateral investment treaties. Now, FCN treaties are still in force in some parts of the world. So, for example, the United States is still involved in at least 60 FCN treaties. And what an FCN treaty really is more of a generalized economic and commerce agreement. So it's not specifically related to investment or to trade or to any other kind of economic modality, but it is also encompassing a number of different elements of economic modalities, including investment. However, of course, bilateral investment treaties are almost exclusively dealing with investment issues. Now, recently, it is the bilateral investment treaty that has been the standard of protection for investment law at the bilateral level. We are seeing a slight shift in this with the introduction of more free trade agreements, including investment provisions, but for the most part, we have bilateral investment treaties. The first of these bilateral investment treaties was concluded between Germany and Pakistan in the 1950s. And since then, there have been up to and including 2,000 bilateral investment treaties that are in force. I believe the number is closer to 2,700. This is according to UNCTAD. UNCTAD have a very good database essentially that documents bilateral investment treaties which are in force. They're often titled Treaties on the Protection and Promotion of Foreign Investment, and so this should speak to the nature and purposes of a bilateral investment treaty, given the fact that they are essentially created to protect and promote foreign direct investment. You would come to the conclusion that their aims are to protect foreign investment and to promote greater foreign investment in the future, which is argued by a number of different authors as being the primary goal, the grand bargain, if you will, of a bilateral investment treaty. So essentially, we are looking at a bilateral investment treaty as a method to attract foreign direct investment. Home states want their private commercial interests to invest abroad, and host states want to attract that investment into their country. So I'm just going to do a little bit more terminology here, looking at the distinction between a host state and a home state. Essentially, when we talk about a bilateral arrangement within investment law, we are focusing on three different entities and the relationships that those three entities have. We have a home state, we have a host state, and we have an investor. Now, the home state is where the investor comes from, so is the often the location of incorporation for an investor, which is often a private company. The host state is where the investment is being made. So a bilateral investment treaty will be a treaty that is signed by two states, between a host state and a home state, and the investors from the home state, therefore, under the bilateral investment treaty, will have recourse to be able to go and invest in that host state. And that is the relationship that is had between the three entities within a bilateral setting. Now, the reason why this is important is because when we get to dispute settlement and we start to look at, for example, the International Centre for the Settlement of Investment Disputes, the ICSID convention, we will see that what happens is the investor, the private investor, under the bilateral investment treaty between a home state and a host state, has recourse to then go and sue a host state for various breaches of investment protection provisions, often through either fair and equitable treatment or potential unjustified and unlawful expropriation. We'll get to that in the future anyway. But that is essentially how the relationship works, and this investment dispute settlement system is known as ISDS, or investor state dispute settlement. So given the fact that we have bilateral investment treaties and we have so many of them, it is increasingly the case that there are standards of bilateral investment treaties. Essentially, countries like the US and Canada, for example, because they signed so many of these treaties with so many other states, they don't tend to have much divergence in terms of these substantive provisions within those treaties. And instead they rely on model structures. So there is a model template structure for a bilateral investment treaty, and for the most part, in these states like the US and Canada, those treaties don't change very much depending on which country they are being signed. So these are known as model bilateral investment treaties, and the essential rule here is that they will generally be the same in terms of their content and protection, and have very similar structure in terms of how they look. So you might be able to get two different bilateral investment treaties, both signed by the United States, let's say one with Cambodia and one with North Macedonia, and you might be able to just read down both of those treaties, and you might not see very many differences at all, except for the differences in terms of the states that are signed onto it. And so that is what we see when we talk about the model bit structure. And there have been arguments made by intellectuals and academics that this represents a sort of pseudo-multilateral regime, given the fact that if we have a web of bilateral investment treaties that are all essentially very similar in nature, does this not multilateralize the regime itself? This is an argument that is presented by Stefan Schill. Now, there are Stefan Schill, by the way, does not use the word pseudo-multilateral. He uses multilateralization. And there are arguments that are presented here. We'll get to those arguments maybe in future lessons time as well. So given the fact that we have a standardization of a lot of these bilateral investment treaties, what are the contents that we will often see in a bit? What if I was to pick out any bilateral investment treaty, what things would I expect to see? Well, we will usually see definitions at the beginning of all bilateral investment treaties. So the definition of an investor, the definition of an investment. This is really essentially the scope of protection, the material and personal scope of protection. We will then start to see the actual protections themselves. So we will see firstly national treatment standards, most favored nation treatment standards, full protection security and security protections. There will also be fair and equitable treatment protections, and then there will be things relating to the expropriation of an investment. So where a host state, for example, nationalizes an industry or takes the investment away, they expropriate that investment. And what are the rules to A, allow an investment to be expropriated, and B, to allow compensation where a lawful expropriation has taken place. And then there will often be provisions relating to dispute settlement. So where a dispute arises, they will be referred to an UNCITRAL arbitration tribunal or an ICSID tribunal, etc., etc., etc. And essentially, we can look at these different provisions and we can unpack each of them, and this will represent this course for investment law. This will represent the next series of lessons. So after we've focused on the actual structural content of investment law by looking at the different treaty structures that exist, we're going to move on to looking at the definitions of investors' investments. We're then going to start to look at the standards of protection. So the national treatment, the most favored nation, the fair and equitable treatment protections. We'll then look at expropriation and dispute settlement, and a couple of other bits therein as well. So we will examine this in more detail in the future, but bits are incredibly controversial in terms of their efficacy and their influence. So I mentioned earlier on that the aim of a bilateral investment treaty is to protect an investment and to then also promote foreign and direct investment in the future. Now, according to a number of different authors, so Salkus and Sullivan, for example, make the claim that they neither protect the foreign direct investment that is existing, nor do they also promote future investments in the future. And there's a lot of econometric studies and data on this that really come to the conclusion that BITs don't really work, or at least if they do, they do very, very little. They don't do what are proclaimed to be the case for what is proclaimed to be the case for what BITs are supposed to be doing. And there are other common concerns that exist with the application and the proliferation of bilateral investment treaties. So, like I've said, the first question is, do they even work? If they don't work, then what's the point in even having them? How do bilateral investment treaties impact the policy space for host states to regulate on important matters? One of the things that we're going to talk about quite a lot in relation to a critique of international investment law is referring back to this idea of policy space, referring back to this idea of imbalance that exists. Why is it going to be the case, as we will see in the future, that there are often lots of protections and rights that are granted to the private investors, but there are often no rights or very few rights that are given to the host states? And equally, there are very few obligations that are given to or that are imposed upon investors, but there are quite substantial obligations that are imposed upon host states. Does a bilateral investment treaty create something of a chilling effect where it locks in the ability for a host state to regulate on important matters? And by important matters, we're referring to the proliferation and regulation of human rights, of the environment, of public health, for example, all of these different things. And could an investment make an adverse impact on those particular issues, especially when we talk about regulating the environment and energy, the investments within the energy sectors? How does ISDS impact the influence of bilateral investment treaties? So ISDS, as I mentioned, is the investor state dispute settlement system. And there are 2 points that I've mentioned here. This idea of arbitration without privity, which is an argument that I'm going to get to in the future as well, talking about very briefly talking about the fact that essentially a host state, when they sign a bilateral investment treaty, opens the door to any investor to sue on the basis of a breach of that bilateral investment treaty. And so there is a sort of asymmetric understanding of of members of litigation, essentially, whereby the host state does not know who is going to be they're going to get sued by. And so we talk about this idea of arbitration without privity, and we'll refer to the Paulson argument and the Paulson paper that actually makes this particular argument. There's also a lot of controversy around the most favored nations standard. We'll talk about how it works within the bilateral setting, and we'll talk about the argument that was presented by the arbitration in the Mefazini and Spain arbitration, which we'll get to in the future as well.